one thing too, Eric.
All good, sir.
All right, thank you. Well, I am very excited. This is the webinar is live. Okay, so good. Very excited today to Life's Co-Pilot. We have Jeffery Stinson with Stinson Elder Law, who is going to be here today and talk to us about something that, frankly, I think that is far more common than we want it to be, and that's why we're having this today. And what we're talking about is that there are so many myths and confusion and misinformation that's out there about what you can do with with Medicaid and Medicaid waiver and all these different things that are out there. And we've got an expert here that's going to explain it to us. So Jeffrey, I'm gonna let you go ahead and explain who you are and what you all of the things you do. And then I think you have access to do a screen share. So just take off and take us down this path.
All right. Well, good evening, everyone. Again, I'm Jeff Stinson. I am an elder law attorney. I'm actually a certified elder law attorney as certified by the National Elder Law Foundation. And what that means is I carry a specialty designation that only a handful of attorneys in the state of Indiana carry. So simplest form just means I've been tested, peer reviewed, and I have to check in every few years to prove I still know what I'm talking about. So that's kind of me in a nutshell. I've been out on my own about 10 years now. Prior to that, I worked for an elder law attorney for another 13 years. So actually 11 years. So it's been about 21 years, I guess, in total that I've been kind of in the area. And so that's all I've ever done as far as my legal career. I've helped folks who are just in need of long-term care, and we work to protect their assets from the cost of long-term care, and in particular, help them access valuable programs like Medicaid and VA. I put this kind of presentation together just to have a little fun with it. I kind of took the whole concept of the Mythbusters TV show, and we're going to take some VA and Medicaid myths and we're going to bust them today. So I hope you find some entertainment out of this as well as some education. And I'm just going to dive right in here. All right. So I think, Jim, just to check me.
It looks good.
Looks good. All right. Well, I'm going to get started here then. I always like to start with facts and figures just to kind of put in context why we're even talking about this stuff. Because I'll be honest with you, 20 some odd years ago, I bet you more people needed to worry about, say, death taxes than long-term care costs. But long-term care costs have now become the single biggest expense that can jeopardize someone's savings. So the reason being is, just give you some statistics there, and I will tell you these are a couple years old, so I bet you they're much higher than what they are even in today's presentation. So if you're looking at nursing home care in a semi-private room, you're looking at about $86,000 a year. Assisted living, $55,000. Not much, just about the same for home care. And that's only 44 hours a week. We're not talking 24/7 care there. And I think the biggest thing that always stands out to me, about 60% of people in Indiana nursing homes have been there greater than a year. So a lot of folks have been paying that $8,000, $9,000 a month for a good long time. A little more in my introduction here. One more thing that I always like to point out is, the reason why I do what I do is few people can afford to self-pay at $8,000, $9,000 a month for their long-term care. So they have a need to look for outside sources. And in fact, nearly everyone's going to need it. About 70% of folks over the age of 65 need some sort of long-term care. So I'm going to jump into some of the myths here. And myth number one, I think this is probably the number one thing, because I still, even doing this over 20 years, I still get clients who just don't believe me that you don't have to be completely destitute in order to qualify for Medicaid. So myth number one, Medicaid benefits are just for the poor, right? Well, no, not exactly. In fact, Medicaid did start out as a health insurance program for the poor back in the late 1960s, early 1970s. But it's grown to be essentially long-term care insurance for the middle class. And this all started around the late 1980s with a set of laws that created some safe harbors, or I call them buckets of safety, in order for folks to be able to protect some things. They are statutory defined that says, we're going to allow you to keep things in these buckets and still qualify for the benefit. So the point being, impoverishment is not required. You don't have to be destitute, but you do have to have a legal plan in place to be able to take some of these things that are exposed and put them in those safety buckets. And in fact, Medicaid not only is not just a benefit for the poor, because it's become long-term care insurance for the middle class, it covers about 2/3 of long-term care. So I'm going to bust that first myth. Myth number 2, Medicaid only covers care in a nursing home. I'm actually so happy to be able to report that this is a myth, because when I started, a couple decades ago, that really was the only option. If you needed help and you couldn't afford long-term care, the only program that our Medicaid system covered, another service, I guess I should say, was nursing home care. But fortunately, the state of Indiana has been growing their service package, and they're actually quite generous with alternatives to nursing home care. We call them home and community-based alternatives. So through what they call a Medicaid waiver program, and that essentially what that means is Indiana's went to the federal government and said, we want to offer more things than just nursing home care. Federal government says, that's fine, state, you can do that. And so through these waiver programs, Indiana Medicaid will actually help pay for assisted living care, in-home care, adult daycare, and adult family care. So no, Medicaid does not only cover care in a nursing home. There's plenty of alternatives to nursing home care that Medicaid will cover. So again, I'm going to bust that myth as well. Myth number 3, and if you get the theme here, these are all questions. When I put this program together, these are all statements that were made by my clients in like we'll just call it a 6-week period of time. So these are things that are still fresh with people. And this comes up often too. My spouse needs care. So therefore, we've got to spend all our assets before she or he will qualify for benefits. Well, as I mentioned, Medicaid has become a program that's basically serving as long-term care insurance for the middle class. And you don't have to spend all your assets to qualify. And I'm going to use some illustrations here in a minute. But again, you do have to have a legal plan to be able to fit within these buckets of safety. In particular, though, when a person has a spouse at home, so in other words, the spouse that needs services, if they have what they call a community spouse, the spouse that does not need services, the eligibility criteria, and in particular, the financial eligibility criteria, is much more liberal than the criteria that's applied to someone who's single. So, no, couple things that we'll see here in this illustration in a minute. If your spouse needs care, first of all, a good chunk of your marital assets are protected because Medicaid allows a well spouse, a community spouse, to keep more assets for themselves. In addition, with some planning, we have the opportunity to put some of those things into the safe buckets. And again, the reason being, through the rules over the years, a Medicaid applicant must have countable assets under that liberal resource limit. And I guess I should pause and kind of tell you what I mean by liberal. If I'm single, I can only have $2,000 in countable assets. But if I'm married, I can have up to a little over $137,000 in countable assets. And that's just countable assets. We still then have the opportunity through these safe harbors within the Medicaid program to reinvest excess countable assets into something that's exempt under the program. So I'm going to introduce you to Howard and Marion Cunningham to help illustrate this point. So here's Howard and Marion. Howard was diagnosed with Alzheimer's disease about 3 years ago. And Marion had been serving as his primary caregiver, but the increasing burden of his care and her age was just making this unsustainable. So after a bad fall, Howard was admitted to a nursing facility, and that facility has a private pay rate of $7,500 a month. Now, Howard and Marion have some assets here. They have a house. It's valued about $125,000. That was a couple years ago, so we know in today's housing market that's probably like $300,000. But for our purposes, it's $125,000. There's a $20,000 mortgage, so net that's about 100. That is 105. Oops, I'm sorry. They have joint bank accounts of $10,000. Marion's got a CD in her name of $40,000. They've got a joint brokerage account. It's got a little over $255,000. They own a car. It's worth about $15,000. And Howard has some term life insurance. It doesn't have any cash value to it, but at his death, it does pay out a portion. So in total, they have about $425,000 in assets. Now, again, Marion and Howard don't have to be completely destitute. Marion doesn't have to be writing checks for $7,500 a month. There's some things she could do. And we start with looking at, they've just got some exempt assets. The home, that life insurance policy, because it doesn't have any cash value to it, it's exempt, as well as the car. Those things are all exempt. So the things that create a barrier to Medicaid eligibility are the things that count. They've got a bank accounts, and they've got a CD, and they've got a brokerage account. And you notice I've been saying they. I didn't build this myth in, but one thing I often hear is, well, they only look at what my husband has. They don't look at my stuff. When they're determining eligibility for a married couple, they're going to look at his assets, her assets, and their assets. So they're going to look at everybody's assets. Sorry for the tangent, but I thought that was an important thing to mention. Back to Howard and Marion, they got a $305,000 in countable assets. And Medicaid allows Howard and Marion to keep $137,400 in countable assets. So the result is they got to do something with $106,600 to qualify. Yes, they could pay Howard's bill at $7,500 a month, and after a while, they'll be down below that standard. But that doesn't help Marion out at home. So what else could we do here? Well, I'll give you an example. So again, we've got a shelter about $167,600. Well, one thing we could do, or Marion could do, pay off their mortgage. That's taking $20,000 that's sitting in a bank account that counts and applying it towards an asset that's exempt. The other thing that Marion can do is purchase an annuity. Now, we have to be careful with annuities here. Medicaid has precise criteria on what makes an exempt annuity. But and I'm not, for the purpose of this program, I'm not going to get into that, but we're going to say this is one of those annuities that fit within the criteria. So when she purchases an annuity, it says she's going to get monthly payments back out of that initial purchase. Medicaid says that's exempt. So when we're all said and done, if you remember before, we started out with $425,000. Guess what? When we're done, they still have $425,000. It's just that their portfolio looks a little different. They have a house without a mortgage now. Rather than having a bunch of money in a brokerage account, now Marion has some money in an annuity. But at the end of the day, Marion's still worth $425,000. Howard has help for his $7,500 a month nursing home bill through Medicaid. And Marion's not worrying about maintaining her level of care, her standard of living, simply because she has a huge bill, potential huge bill for Howard. So I'm going to blow up that myth that you have to be completely destitute, you have to be destitute before your spouse can get help. All right, another common myth that I often hear. My health is failing, so I should just give everything away to my family so that I can qualify for Medicaid and VA benefits. And here I'm going to say, be very, very careful. There's lots of reasons why you want to make sure you talk to an expert in this area before you make any gifts. Because not only does Medicaid and VA have strict rules against giving things away, they don't want you to give everything away and then the next day say, here I am, I'm eligible because I don't have anything. They have rules that I won't say prohibit, but create a barrier to you getting benefits over a period of time because you give stuff away. And the other thing that we're going to need to be aware of is it's more than just giving money away. Sometimes it's transactions that are considered gifts. Sorry, went backwards. I'll pull that up twice. All right, so transfers under Medicaid and VA. The first thing to know is when someone applies for Medicaid, they're going to look, Medicaid is going to look back 60 months, and they're going to look for things that were transferred away. Things like just regular old gifts. In addition, anything for like sales for less than market value. That's one that comes up often. Well, Jeff, I didn't give my car away. I sold it to my son for $1. Well, that car was worth $20,000. You actually made a gift of $19,999. There's also certain financial transactions. I mentioned annuities earlier. If you purchase the wrong annuity, you could be subject to a lengthy transfer penalty. For VA, there's similar rules, except it's a little shorter. When you apply for VA, they're going to look back 36 months, not 60, 36, but they're still going to look back to see if you've given anything away during that period of time. And as a friend of mine says, but wait, there's more. And that's because any transactions between family members are automatically presumed to be a transfer. That stinks. It's so if I hired my Uncle Jim Morgan, it's not my uncle, but using my example, I hired my Uncle Jim Morgan to paint my house, and I paid him $5,000, but I don't have any evidence to prove that he really painted my house. Medicaid is going to call that a gift and penalize me until I go in and say, okay, here's receipts, here's everything that showed that he painted my house. So that's another issue with transfers. When I'm talking about penalty, we'll transition into this a little bit. What we're talking about is a period of time where both VA and Medicaid says no help. Because you gave something away, we're not going to help for a period of time. And there's a formula they use to calculate that. And I give an example of just a $20,000 gift is about a 3-month penalty under Medicaid and about an 8-month penalty under VA. Some things to know, though, is there is a 5-year cap on a transfer penalty under VA, but Medicaid, it can be unlimited. So if you give away, I don't know why you do this, but if you give away $1 million to a family member and you apply for Medicaid, you could be penalizing yourself for a decade or more. So all of these things are not something that I'm saying you need to become an expert, but if you're thinking of making a significant gift, you really ought to talk to someone first. I didn't even mention the fact that by making gifts or putting names on houses and things like that, you've also subjected your asset to the whims of what might happen to that person you added to. So for example, if you add your son to your house thinking, I'm doing my own Medicaid VA plan, I'm going to protect that house by putting him on there, but he has a list of judgments a mile long, all of a sudden, all of those creditors can start putting liens on your house. So there are other things that you need to think through there. Big thing to take away here. Don't just up and give everything away thinking you're going to help yourself becoming eligible for these benefits programs. Seek out legal counsel before you do so. One other thing I will take a side note though and mention, I don't want to scare anybody into not making what I call your normal gifts. Do take care of your grandkids at Christmas. Do take care of your kids on their birthdays. What I'm really referring to is I suddenly decided I want to give $50,000 away to my kid. That's what we're talking about here. If you've always given your kids $100 for their birthday, that's not going to be an issue. But if you give them $100 and all of a sudden you give your kid $100,000 one birthday, that is the problem. So again, don't just give everything away if you need these benefits. Talk to somebody first. So I'm going to bust that about giving everything away to become eligible. Okay, next myth. My dad is a widower and just moved into assisted living. I will need to spend all his assets on his care before obtaining Medicaid assistance. So my previous example was a married couple, and we reinvested some things so that the well spouse wasn't completely destitute. Now this is a little different. This is a single individual, but nonetheless, we can still protect some of this money without being completely impoverished. So it's not necessary that you spend everything, but we may need to do some planning. And this is going to break down into what I've kind of coined a couple terms. One is a half and half plan, where we set aside a half of these assets that are protected, but knowing that because of the transfer rules, we may have to private pay for a period of time. And I've got an illustration for this. The other is what I call the discount plan. And that's where a single individual sets some money aside, knowing that my estate may have to pay some of this money back, but at least I've gotten the Medicaid discount. And I've got an illustration for that as well. So let's start with the half and half plan. And here we're going to introduce you to Arthur Fonzarelli. So Arthur's 81. Again, he's single. He's the widower. Declining physical health. So just recently moved into an assisted living facility. And he's got $150,000 in assets. The assisted living's costing him about $5,500 a month. And he's got about $2,000 coming in. So his monthly shortfall is $3,500. Now, he could do nothing and just spend his savings. And I've done the math there. About 42 months, he'll have nothing. And he'll be eligible for Medicaid. But that doesn't help him after Medicaid's in place with paying for things that Medicaid doesn't pay for, like toiletries, like haircuts, like his favorite snacks, like trips, like entertainment. Those things aren't there. So if we change this a little bit and do some planning, he can set aside some assets so that there's some assets available to take care of those things, even once he obtains Medicaid. So we do this through what I call the half and half plan. And again, what we do, I call it half and half, but usually we protect more than what we have to spend on care. And I know a lot of my colleagues will call it the burn share. I don't like that, but really that is kind of what you're doing. You're burning through part of your assets in order to protect some of your assets in this type of plan. So essentially what happens is Arthur's going to allocate a certain portion of his assets to his family. We call that the family share. And in his circumstance, the math kind of works out to where he's going to put $96,000 aside. There's going to be a Medicaid transfer penalty for that. So he's got to have some money to get through that penalty period. That's where the care share comes in. And with his shortfall, he needs about $54,000 on that side. So with the half and half plan, what we're doing is we're accelerating eligibility. We're going to establish eligibility before everything's gone. And we're going to protect some of his assets. And how that works with the $96,000, generally what I'm doing is we're gifting to a trust where the kids are going to agree, we're going to pool this money during our lifetimes. Now, during Arthur's lifetime, I'm sorry. Now, Arthur's not the beneficiary, but the trustee can use that trust for family purposes. Even if a family member decides, you know what, I think I want to use some money for dad. That distribution can happen to one of the kids and they can use it for dad. Now, of course, Arthur needs to understand this is a completed gift and he can't direct them to do that, but they can if they want. And then at his passing, everything's split into equal shares. Now, the reason why I do that in a trust is, that, again, think back to what I just said about adding a kid to real estate. By putting it in trust rather than just giving it to the kids, it protects it, one, from being spent during Arthur's lifetime, but two, it keeps it protected for anything that might happen in those kids' lives, whether it's a divorce where a potential ex-spouse is trying to go after that money, to a creditor, to someone just becoming disabled and needing to make sure that stuff is protected from their own special needs. Now, that's the protected part. What we know is if he gives away $96,000, Medicaid is going to say, well, we're not going to help you with your assisted living bill for 54 months. So he's got to have some money to get through that 54 months. And that's where the care share comes in. Typically, we'll take that $54,000, we convert it into a stream of income that pays about $3,500 a month, his shortfall for 54 months. The end result is, with this half and half plan, remember at 40, if he just paid his bill privately in 42 months, he was left with nothing. With the half and half plan, he has Medicaid in 15 months and he's still protected $96,000. Now, I mentioned there were two ways here. There's the transfer half and half plan, and then I call this the discount plan. I'm going to introduce you to Al here. So Al's 81, single, declining health, recently moved to a nursing facility, and his family's uncertain how long he's going to live. Doesn't think his life expectancy is real long. And he's got $250,000 in total assets, and he's got $8,000 in monthly costs and $2,000 in income. So his shortfall is $6,000. If he just spends this, he'll be out of money again in 42 months. A half and half plan would require Al to wait about 20 months between what he would put into that family share versus the care share. And again, family just isn't quite sure Al's health will sustain him for 20 months. So doing a half and half plan is probably not going to give him any benefit, because Medicaid is not going to kick into month 21 and he may pass away before then. But we can still take advantage of Medicaid's lower reimbursement rate. And that's why I get this Medicaid discount rate. And here's what I mean by that. If we just take his $25,000 and turn that money into a stream of income. So maybe he loans his money to a child or he purchases an annuity. What happens then is that $250,000 is turned into paying $6,000 a month to him. Now he's immediately, turning into a loan, pays $6,000 a month to him. Now he immediately qualifies for Medicaid. He has $250,000 behind him because that's in the loan. But he also immediately qualifies. There's no look back period. There's no transfer because he hasn't given anything away. He's just loaned it out. Now, the downside to this is Medicaid is going to have a claim against his estate. So if there's any of that $250,000 left when he passes, Medicaid gets first dibs on it. But if Al lives 12 months and Medicaid submits a claim for $48,000, and that's because they're paying $6,000 a month, whereas Al would be paying $8,000 as a private pay individual. So backing up a minute, the benefit here is by becoming Medicaid eligible, yes, he may have to pay the money back that Medicaid's paying out as benefit, but Medicaid's paying out at a rate $2,000 less a month than privately. If he's paying privately, in all, it's $8,000 as a cost, but with Medicaid's negotiated rate, it's $6,000 in cost. So even if he has to pay back what Medicaid's paying, he's still ahead. And that's where I get my math here. He'd be ahead. Medicaid would submit a claim for $48,000 because they've paid $4,000 over 12 months, but he's still better off than if he would have paid privately over those 12 months. So the discount plan gets him immediate Medicaid eligibility. Countable assets are converted into something that's safe. Yes, the state of Indiana might have a claim, but because of Medicaid's lower reimbursement rate, his private pay rate versus the private pay rate, what he's paying out is less. So he gets about a 25% discount there. So I'm going to blow that one up. All right. Next myth. I'm going to put all my assets into a Miller trust to protect them. No, you're not. This is pretty common. I understand why. Indiana changed their Medicaid program back in 2014, and what was created as one of the things that were created as part of that change was what's called the Miller Trust, otherwise known as the Qualified Income Trust. The Miller Trust is a safe harbor to get around the Medicaid income cap. It's not a way to protect assets. And I think there's a lot of misconception about that. See, what happens is Medicaid since 2014 has had what they call an income cap or a special income level. So if I have more than $2,523 in monthly income, I'm not going to qualify for Medicaid. So if I have $2,525, I just have $2 over there. I'm not going to qualify for Medicaid because of that $2 extra a month. So the solution is creating what's called a Miller Trust, or also known as a Qualified Income Trust. And that's a safe harbor created by Indiana law, federal law actually, that allows folks that has excess income to put into that trust. And what essentially happens is Medicaid says any income you put in the trust is not yours anymore. So in my example, if we're $2 over, if you put $2 into that trust, all of a sudden I'm down below the cap. Now the trust itself just operates as a conduit. And if we just get rid of the names, trust, and all it is a bank account that you set up at the local bank, and you open a checking account, you put $2 of income at least in that, in my example, a month. That $2 just flows right back out to be used for your services. But by using that conduit, you've gotten below the income limit. So bigger point though is you never put assets in a Miller Trust. The Miller Trust is to help protect income and get over the income cap. So I'm going to bust that one. Myth 7. I'm going to lose my spouse's income when he starts to receive Medicaid. Now here, I'm going to give you a little bit of leeway because it really depends, and that it's dependent upon what the spouse's income is. You know, typically Medicaid requires a recipient to use their income or let me say it differently. Medicaid typically pays the difference between the individual's monthly health costs and their income. So the individual is kind of required to use their income as a co-payment. So if I'm single and I'm in a nursing facility and I'm getting $2,000 a month, in general, I have to pay that $2,000 to the nursing facility. It's what they call a liability. And then Medicaid pays the rest of the nursing home bill. However, there are situations where if the spouse at home does not have income up to a certain level, Medicaid will allow that person to have some of the institutionalized spouse's income. They call that a spousal allocation. So if the non-recipient spouse's income is below that minimum amount, and in 2022, that minimum amount is $2,155. So using an example here, if the nursing home spouse has $1,000 a month and the person at home has $1,000 a month, they're going to get to keep all the nursing home spouse's income because that still keeps them below that $2,155. Now, if the person at home has $3,000 a month income, they're probably not going to get a spousal allocation. However, there is a way to increase that minimum number, and that's based on excess shelter costs. Medicaid says we'll let the spouse at home should have to spend this much money on their room and board, housing, utilities, things like that. And if they still pay more than that, we'll let them add to what's allocated from their institutionalized spouse's income. Now there's a cap on that of $3,216 a month. However, we can still go further. If that's still not enough to meet that person's needs, we can always ask an administrative law judge with Medicaid or a trial court judge to create an order saying, I think he or she should really have even more than that. So we can always seek that with a court order if we can justify the need for additional expenses. So yeah, kind of a busted myth. You might get to keep some of your spouse's income if you're below that threshold. If you're above, you won't. But I'm going to say it's busted just because I like to blow stuff up. Myth number 8. We're going to transition into VA pension. We've talked a lot about Medicaid, which kind of operates as insurance. If I need Medicaid benefits, they're going to pay providers directly. Now, VA has a pension that allows me to get a cash benefit coming back every month when I meet their criteria. So we're going to go through some of the myths of VA pension. First one is, I hear this a lot. You know, Jeff, I'm a veteran, but not career military, so I don't qualify for VA pension. And I bring this up because I think VA's label is a little bit misconstrued, because I know a lot of people think of pension, that's because I've spent years in the military, that's retirement, but they actually call that military retirement. Pension is again, a cash benefit for veterans or surviving spouses of veterans that have a non-service connected disability. So for example, in 2022, a married veteran can get up to $2,431 a month in VA pension, and a surviving spouse can get $1,318. So this becomes ideal for lower levels of care. It doesn't work well with nursing home care just because of the cap of the amount that's there. But for folks that need assisted living or home care or adult daycare, this is golden, because oftentimes that little extra cash is enough to help pay for those levels of care. So I'm going to bust that one. Second thing I often hear in regards to the veteran piece is, you know, Jeff, I've served during wartime, but it was at stateside. I never went to the battlefield. I wasn't at the front, so I don't qualify for VA pension. And fortunately, you don't have to serve in a war zone to qualify. You just have to be active during a period of war. So again, they're going to look, do I have active duty? Was I discharged for reasons other than dishonorable? Best is, was I honorably discharged? But there's other levels there, as long as it wasn't dishonorable. And I've given you some of those periods of war. So it doesn't matter if I was just a typist in Maine during World War II, as long as I was active duty, I qualified. It doesn't matter if I was in Germany or Japan or wherever. Same thing with the Korean conflict and the Vietnam conflict. The only caveat I have there, and I actually didn't add these dates, from 61 to 64, you can still qualify. That one, though, does require you to step foot in Vietnam. Otherwise, these other dates, it doesn't matter. As long as you were active, it doesn't matter where you were, you meet the definition of veteran under the pension program. So I'm going to blow that one up. Next thing, Jeff, my income is too high to qualify for VA pension. Well, you know what? If you have any type of long-term care expenses, generally it's not. And that's because of what VA calls an IVAP. Income for Veterans Administration purposes. And all IVAP means is I have medical expenses that exceed my income. That's how you get the maximum benefit. Now you can have an IVAP of $3. It just means you'll get the maximum benefit minus $3, because you still have $3 you can use on your care. But if you're in assisted living, for example, paying $5,000 a month, and you only get $2,000 a month in income, you have a negative IVAP. So they say you qualify. So I'm going to bust that one as well. Another myth with VA, my assets are too high to qualify for VA pension. Well, just like we saw in Medicaid, there is an asset limit under the VA pension, but as long as you're able to do some legal planning, you're able to protect some of those assets, and you don't have to be completely destitute. And in fact, VA is much better to folks than Medicaid. And that's because a veteran or the surviving spouse can have $138,489 in covered assets. Now, not to get into too much detail with Jim, but Jim and I, we kind of know this VA pension program. We've worked together in the past. And that wasn't always the case. They never give us a bright line standard. They used to say, yeah, whatever we think is too much is too much. And so we used to be very conservative. Actually, a couple of years ago, they give us this bright line standard. So we can start at 138,000 in covered assets. And then there are also exempt assets. And then keep in mind, even then, we can still look at transfers to see if we can protect some assets. And I'll give you an example here. We're going to take Howard again, and instead of the nursing facility, Howard, he's going to get some home care. He's a World War II veteran. He's got about 315,000 in assets, consisting of a house, bank accounts, CD, broker's account, car, and life insurance. He's got Social Security of $2,000 a month, home care of $2,500 a month. So his income for Veterans Administration purposes is good, because they're going to take, even though he's getting $2,000 a month, they're going to subtract his $2,500 a month in medical expenses and say, hey, you actually have a negative IVAT. They actually treat it as zero, but the point being is he passes the income screen. So the next thing we're going to look at here is, of his assets, are anything exempt? Yeah, his house and car is exempt. So his excess assets, then, he's got 175 in countable. He can keep 138 or so. So his excess assets are $36,511. So what could he do? Well, he could purchase a funeral, because prepaid funerals aren't considered a countable asset under the VA. He improved his house. Maybe it's making it wheelchair accessible. Maybe it's just getting it in saleable condition for what might happen in the future. But he spends a little money on his exempt house. And then he does make a gift to the family trust. And by making a gift of $6,500, he's got a 3-month penalty. But after 3 months, he starts getting that roughly $2,100 a month almost immediately. So there is still some opportunities there to protect assets and qualify for the VA. So I'm going to bust that one. And with that, I'll turn it over. I don't know, Jim, how many folks we might have with questions. I'm going to, I always, sorry. I always invite folks, our firm web address there, your email address is there at info@stinsonlawfirm.com. I get a kick out of this program. So if anyone has their own myths they would like me to bust, feel free to send it, because I would love to bust your own myth, so to speak. But if there's any questions, I'm willing to take them, or anything else we can do. I'm here.
Well, that's great. This is such good information, because most people don't know. I mean, I still hear people who believe that they have to get a divorce to protect assets and stuff like that. And as you've told before, that's like the worst thing they can do. Yeah. But it's still that myth that floats out there.
Yeah, I had a couple just today that had that myth. And what Jim's referring to there, obviously, if there are other things going on, maybe a divorce makes sense. But if someone's looking at a divorce solely for the reason of long-term care costs, we can typically protect more marital assets when folks are married than single. If you kind of look at my illustrations, Howard and Marion, we're able to protect everything for Marion. Whereas with Arthur, when he was single, we would protect some, but not all of it. So you're right. Getting a divorce for the sake of long-term care is probably the worst thing you could do if you're trying to protect assets.
Yeah, and that's been that way since what, about the 80s or
1988?
Okay.
When that,
so this myth's been going on for 30 years or so. So
right. Yeah.
So that's frustrating. And that's one of the reasons we have these events, to try to get this information out. One of the things that we'll do with this video, it goes into our Life Copilot library. But also what I'll be doing is cutting it up into smaller segments. I'll probably do a myth each, and then that'll go into a portal where you can get, short-term answers to things as well.
Great.
But so what are the things that you probably have, you just did your myths, but I mean, what are you still seeing people walking through your door, believing or what have you that may not have been part of your myths?
Well, I didn't mention this as a myth, but one thing that comes up often that I hear is, my neighbor, or everyone has a neighbor or a friend or somebody that did some type of planning in the past. I don't say everyone, but I hear that often. And I caution folks, because what fit for your grandma may not fit for your mom for a number of reasons. It's just a different circumstance, first of all. But the other thing that happened from generation to generation, rules have changed. I'll tell you, back when I first started, there was no estate recovery against assets outside of what were probate assets. So if you had stuff in trust or joint name, Medicaid didn't have any rights to recover that stuff. For the most part, the look back period was 36 months. The transfer penalty started immediately, not when you needed services. So there was a lot of things that were much easier to do, I guess I should say, back 15, 18 years ago. So it's very dangerous to rely on the advice of somebody, what your neighbor did with their mom 10 years ago, or even 5 years ago, because things change. That's a big thing. The other is, I just do your own research. There's lots of stuff out there, and even if it's checking in with someone like me and getting a couple hours of her time, you're going to have some value in that, simply because there's so many things out, so many ways that you can get sideways on some of this information. I hear that a lot. They're going to take my house, or they're going to take my bank account, or and I never really know. We talk about, well, who's they? Well, I don't know, but I've heard they're going to take it. So oftentimes I think they think the nursing home is going to take it. Nursing home's not going to take anything. They're just not going to help you if you don't otherwise qualify, or the state's not going to take anything. But I hear that a lot too. They're going to take my stuff. So talk to somebody. I guarantee, even if it's a couple $100, it'll be the best couple $100 that you've spent, just for peace of mind's sake. Even if you don't have to do anything to qualify, it's nice to hear you're okay.
You brought up earlier that we had a relationship, we're a family member for me. And, previous to that, my earlier experience was dealing with my father-in-law, who's long passed, but I didn't know what I was doing. I'm trying to fill out these VA forms and trying to get it done. I kept getting rejections. And because I didn't know what I was doing, okay, I didn't know how to cover dot the I's and cross the T's properly. And 18 months later, I'm still getting rejections from that. And I ended up calling Congressman Burton's office, because I had a relationship with them, and they got it for me in 24 hours. I'm going, you shouldn't have to know a congressman, to get this done. And then I was turned on to you several years ago, and it's a totally different experience, because knowing how those rules are, and even the rules that we operated under have completely changed from that time frame.
Yeah. Significantly. Yep.
Yeah. I mean, significantly changed. Yes. So it's like, so just because if I was sitting there with what we had done 5 years ago, approximately, and try to tell people how that worked, well, that's not how it works anymore.
Right. Exactly. I have this area of law is a lot of fun, simply because it changes a lot. So there's always something new to learn, and I love to learn new stuff. But at the same time, it can be very exhausting, because things change a lot. I don't want to besmirch any other area of law, but if you're a trial attorney, things have been pretty much the same since, well, at least since the 60s, when we had a new rules of civil procedure. So for us, we're constantly looking at something different, and it can be taxing at times.
Well, I was going to say, just for the people we've got several people watching right now, I was going to say, if you want to, you can raise your hand, you can do a chat thing, you can do a Q&A, and we'll be glad to get your questions on here. But so what, I know that, and again, the VA rules and the Medicaid rules are similar but different. Okay, so that's kind of, can be confusing as well. And one of the things that I think that you can have both, can't you? You can actually do, you qualify for both Medicaid waiver and VA aid and attendance if the right things are set up properly.
Right. So you hit the nail on the head, and that's Medicaid waiver. And actually, let me be crystal clear. You can have both, no matter what level of care you need. It's just that if you're in a nursing home, VA is only going to give you $90, no matter what. But if you need home care, assisted living care, or adult daycare, you can potentially get both. You can both get help from Medicaid and get some help through the VA. And that helps a lot of clients because, Medicaid might help pay the assisted living bill, and then you can still hire some private caregivers to give some extra help, even in the assisted living, through the cash coming from the VA. So yeah, you can get both.
Yeah, I think that a lot of people don't realize that as well. So because it normally would put you into, that's where also that Miller Trust comes into play a lot of times too, because you may have income coming from two sources and it gets, confusing. I will tell you this much about our situation is I bring my wife in and show her all the way we have all the accounts set up, and she goes, if something happens to me, she's calling you. So just be prepared. So because her eyes glaze over and she walks out of the room. So but anyway.
Yeah, well, that's what we're here for.
Yeah. So it is confusing. Like I said, I always tell people it would be. I know enough to be dangerous. I can tell you that these things are possible. I couldn't tell you how to set them up, so.
Mm-hmm. Sure.
So nor do I even want to know. So,
Yeah.
But these are things that, I know that myself, just being in this world now and working with people like yourself and learning these things has taken a tremendous amount of fear out of my life, because I've watched family members that literally overnight their assets are gone, and then you're going, what do you do? So it's,
Mm-hmm.
and Medicaid only paid for a assist, like a skilled living or a nursing home. Most people don't need, they may not need that, not till the very end of their situation sometimes. So all of a sudden how do you fix it? This information is, I will tell you, it's easier to sleep at night.
Yeah. I had a client that actually this afternoon that called the planning we were doing dad's sock money. And her question was, well, if dad's receiving Medicaid benefit and what happens if he doesn't have anything? Where does his socks come from? And so I said, well, what? She said, well, good. So by the planning, he's going to have some sock money over the next few years. I said, yeah, he's got sock money. So
exactly. And it's, we've been down these paths with our family members before. We didn't know people like yourself, at that time. And like my mother-in-law, we followed the advice that we got from our assisted living places, which was not necessarily all that strong. Okay. And we literally burned through every dime she had. Okay. And then we're going to have a conversation with her that we're going to go to a Medicaid place, after that. But at that point, well, she passed, so it didn't ever happen. But it was literally, we had followed the myth path, and burnt through literally every penny she had, trying to get this, get it done. So it's so that, and I think that's why I'm so passionate about trying to do these panels and to do this information, to let people know you don't have to be in that situation.
Yeah. I can even share a personal anecdote. My dad was, his family was, or his parents was much older than he was. And so to make a long story short, family farm, dad started farming the farm at age 14. And over the years, as things went along here, he was still farming the farm, but then grandma got sick and they paid for her care, everything she had, and then started mortgaging the farm to help pay for her care, not knowing there was anything like this out there. I mean, I was still a kid at the time.
Right.
And to make a long story short, dad suddenly, his way of life, he's now got a farm with all this debt on it that he had to inherit at 50 something and start paying down against, just so that he can continue to be a farmer. So we all have these personal experiences, but you're right. If we had known about this stuff back in the mid 90s when grandma needed the care, dad would have been in a better position. His siblings would have been in a better position than what they were. And we're very fortunate we didn't lose the farm, but that could have been a real possibility, particularly if she continued to need care and with the rate she needed it. So.
Well, that's why we do this. And that's why this video will be cut up into all the little myths that we can start promoting out across all the different platforms. Everybody that's sitting there, they've been really good about staying put, but they haven't put any questions out. So I think we're good. Do you have anything else that you would like to say, or?
No, I enjoy doing this, and I invite anybody, again, if you have your own myths, feel free to email me at info@stinsonlawfirm.com, and we'll not only give you a personal bust of the myth, but I'll also use it in a future Mythbusters. So
Excellent. Well, I know that you've got to go scurry up all about 3 kids and 3 different sports events. So
right.
I'll let you go take care of that.
All right.
And thank you so much for being here. This video will be on Life's Copilot soon for people to be able to watch again. So thank you very much.
My
See you
pleasure.
guys.
Thank you, Jim.
Bye-bye.
Take care. Bye-bye.